Can one lawsuit change the future of AI? Anthropic just agreed to pay a staggering $1.5 billion to authors whose books were used to train its AI, many sourced from pirate sites. This landmark case sets a $3,000 per book precedent and forces AI companies to face a new legal test, not just how they use data, but how they get it. The age of ignoring copyright in AI is officially over. Anthropic's $1.5 billion settlement with a group of authors marks a major inflection point in the ongoing clash between artificial intelligence and copyright law. The case effectively assigns a monetary value around $3,000 per book to works used in AI training datasets, setting a significant precedent for future disputes. Rather than focusing solely on how content is used in training, the case highlights a crucial legal question. How was the data originally acquired? While courts accepted that training on copyrighted materials could fall under fair use, the issue was Anthropic's sourcing of pirated content, which clearly violated copyright law. This introduces a powerful new two-part legal test for AI companies. Is the use of the material transformative, and was the material lawfully obtained? Even if fair use applies to training, unlawfully downloading or acquiring content from pirate sites is a separate, clear-cut copyright violation. Anthropic admitted in court that escalating the case to a certified class action could have posed an existential threat to its business. The sheer size of the $1.5 billion settlement and the $3,000 per book benchmark sets a financial baseline for future plaintiffs. AI companies can no longer treat content licensing as a secondary concern. The cost of getting it wrong is now demonstrably massive. This decision gives authors a meaningful legal victory and solidifies their right to control both access to and use of their works. Authors can now challenge AI companies not just on how their work is used, but also on how it was obtained, expanding their legal leverage. This new dynamic strengthens creators' positions in licensing negotiations, especially when tech companies hesitate to pay. Still, debate continues over whether one-time payments, like $3,000 per book, adequately reflect the long-term value of creative work in evolving AI systems. New compensation frameworks, such as royalties, recurring fees, or usage-based models, are likely to gain traction going forward. For AI companies, this case is a wake-up call. Investing in legal compliance and content provenance is no longer optional. It's essential. Courts are catching up to the AI industry, and the era of moving fast and ignoring intellectual property rights is quickly closing. The settlement suggests that collaborative licensing, not courtroom battles, is the smarter, more sustainable path forward. Creators should work with specialized legal counsel to secure licensing terms that cover compensation, attribution, future use, and data protections. Likewise, AI companies must embed legal strategy into product development, from dataset sourcing to contract enforcement. Ultimately, the Anthropic case shows that innovation and legal compliance can and must coexist to build a trustworthy AI ecosystem.